All right, welcome everybody to our 21st webinar. Again, say this every time, but I can't believe we have a webinar. One of the great things to come out of the COVID era is a little bit better outreach digitally. Today, we are focusing in on whether or not your purchase and sale agreement's binding, both residential and commercial, and a deep dive into specific performance and what exactly that remedy means. We're super excited to have you guys. This is being recorded, but that doesn't really take away from the need to have input. In this discussion particularly, we want to make sure that it is as helpful as possible. So as we're going through, go ahead and use the chat function in Zoom, now that we're all familiar with that, to ask questions as we go, rather than wait until the end. If we don't have any questions at the end, that's fine, but it'd be great to have some during. So don't be shy. If we can't get to them, we'll get to them later, or we'll try our best offline. This is being recorded, so do take a moment when you're done with all this, and you get the email afterwards showing you that it's, you know, how to get a viewing of this on the YouTube, spread around your office. Happy to make sure that it's helpful. Before I introduce our awesome guest, I want to make sure that you also are aware that we're not giving legal advice. This is for informational purposes only, and you should be consulting with your attorney on any issues we discuss here, which obviously may be us, but this again is not advice. We urge you to take a moment and get specific advice as to your facts, because most of today's discussion will be legal. With that, super excited to have our newest partner at Holmquist and Gardner, Rob Maxwell, with me to have a discussion on this. Rob, if you don't know, is just awesome as a human being, but also a great hockey player and a great dad. And we huckle him for other things that we won't talk about. But one of them is not his knowledge of real estate law, real estate transactions, and litigation. He's in the mix on a lot of these issues, as am I. So super excited, Rob. Thanks for joining us today.
Thank you, and welcome everybody. Yeah, we're excited on this topic, and kind of today, just kind of a quick overview of kind of how we want to treat this. Is we want to give you more of a primer and a general feeling for this kind of area, but I also want to welcome in real time questions and answers, because I know everyone that's tuning into these things, it's usually they have something in the back of their head that they're hoping will get covered or at least touched on. So if there's something out there that's just kind of burning there and it's relevant to the topic, it's great to touch on that in real time. And it usually leads us down a path that becomes very informative for everybody else. So welcome any questions during this.
I'll also note that Rob and I could talk for hours about this. So we're going to try and be super quick today. We had a discussion before this and yesterday and preparing for this that, man, it's going to be tough to try our best to keep. We want these webinars to be super quick hits, so you don't feel like you've been on for an hour with us and we've been lecturing at you. So we're going to try and keep our content to 20-25 minutes and then open up for Q&A, but do be asking questions. Whole goal is to kind of keep these to 30 to 40 minutes. So if it seems like we're flying through something and you want further explanation, go ahead and hit us up. That'd be great. So with that, also special thanks to Mike, our PR guy, who puts all this stuff together and helps us with our emailing, and he's in the background moving our PowerPoint around. So Mike, let's kick her off.
All right. Well, so I mean, the first thing we're going to try to cover everything, but you know, as much as we can. But the real big key critical things here that we're talking about is, hey, when is your PSA effective? What are some of the binding terms? What are the material requirements of a PSA, a purchase and sales agreement, going into a process? And, you know, we're going to talk about some of the low-hanging fruit that everybody's kind of aware of, but obviously you're not getting very far if you haven't agreed on a purchase price. You're not getting very far if you don't know what the property is, meaning the legal description or some sort of designation for what that property is. And then there's other terms that go in that aren't as material, but that's kind of the low-hanging fruit of, hey, what does it take to enter into a real estate transaction, whether it's commercial or residential? We're lucky enough here in Washington that we have some very good, it's kind of a form process for a lot of the residential side of things. If anybody's been out there and has gone on the market to buy or sell properties, are probably very familiar, or at least have seen the Northwest MLS forms, which I would say is, running with 95% of all residential transactions in Washington State. And then you also got forms with CEBA, the Commercial Brokers Association, that are commonly used. And it's about same percentage. You'll see almost all those commercial transactions that are utilizing brokers and going through that process are using those forms. So we're going to touch on that a bit today and just kind of some of the terms there. But then really we just want to kind of go through the big picture there of specific performance and contractual remedies and what specific performance really means. Mike, you can go ahead and go to the next page there. All right, so I touched on it, and EMONS is we're going to kind of be trading in and off here, but again, if any questions come up that are in real time, let us know. But I do a lot on the residential side. I also do a lot on the commercial side, but EMONS is also intimately familiar with both sides of the thing. So some of the stuff we wanted to go through, and some of the stuff that we see on a consistent practice basis that gets brought up over and over again. On the residential side, and this goes towards specific performance, but it's also a big thing that you'll see a number of disputes kind of revolving around, which is the seller's disclosure statements, also known as Form 17 here on the Northwest MLS forms. And there's a lot of confusion based around this document. It's not actually technically a part of the purchase and sales agreement, which kind of, it's weird to think about because it's almost always a part. It's always signed and submitted with a package that is the purchase and sales agreement. But Form 17 is actually statutorily based. And so it's a seller disclosure where Washington State has gone out there and said, hey, for buyers out there, we want to have some additional protections in terms of getting information out there that's known to the seller and having a format to do that. It becomes the basis for a lot of arguments on, if you've ever seen one of those forms, and I apologize that I don't have one to show you right now, but you'll notice there's a bunch of tick marks saying, information that is based on the seller's actual knowledge, and it's no, I don't know, not available. So you can see how any of the information that comes up through those can lead someone to looking at that saying, something comes up on their property after they purchase and they're going, well, this wasn't correct. He said there was no cracks in the sidewalk or whatever it may be. But so that tends to come with a lot of the purchase and sales agreement kind of disputes and also the specific performance.
Yeah, and I think you just really want to check the box that you have one. We see a lot of people trying to waive these. The CEBA form, which we'll talk about, has, you can waive in a commercial transaction as long as none of the answers to the questions would be yes on the environmental section, which I believe is section 7, just from the top of my mind. We could spend an hour talking just about how to fill these in. So we probably won't here, but to Rob's point, some people just are kind of confused and they're like, is it part of the deal or not? And it sometimes doesn't get delivered to anybody. It says right in the MLS form, it'll be delivered by this time period, or sometimes it's attached in the exhibit. But if it never happens, then what you've done is just opened up a statutory right of the buyer to just walk away, because they get that review period. And there's a case where this happened, and they got on the closing date and buyer walked, and there was some other issue that happened, and it wasn't even brought to anyone's attention that there wasn't a Form 17, and it got brought up in litigation. Someone said, hey, wait a second, there was no Form 17 here. Judge was like, yeah, we're done. If you deliver that today, 6 months after this was supposed to close, they'd still get their 7-day right of rescission. So the key thing here is just get it put together and make sure it's a part of the deal, or you won't or may not have a binding contract. And we'll get into that in a second.
Yeah, and I want to touch just one other point on that, because it comes up often in the world of brokers and sellers. There's this, I won't say anomaly, but it's kind of become a common practice that I see with a lot of the transactions of sellers wanting to waive the information verification period and buyers wanting to waive that as well. Whereas we see that as a common practice in residential. You'll see on the Northwest MLS that sign marked out and buyer saying they're waiving the right to the informational period. To me, that's almost a disservice to a seller. The ability to have that period there and have the buyer understand that they have that and it's passed, and they're completing a Form 17 and they're putting out the information that they know is available with the property, is actually a complete defense towards a buyer coming back and saying, you didn't provide this, or I didn't know. And so there's a give and take there. And people look at some of those contracts and they say, well, I don't want to give them this right, and I want them to waive that right. And that's fine. That's, you know, that's a decision that can be made, and it's made a lot of the times, but it's also, it can be actually more protection for a seller to have that in place, provide the Form 17, and have the full disclosure. And so that's jumping off tangent a little bit there, but I think that's some really good critical information just on the seller disclosure side. And this is both residential and commercial transactions. There's also the full legal description, and we talked about this as kind of a low-hanging fruit. This is one of those things where, in order for specific performance to go through, you have to have the identification of property. It's a part of the process. So it's not necessarily the full legal description, but the reason we put that there is that's the best practice, right? The best practice is always going to be, hey, any agreement we send out, it's going to have the full legal description attached to it. People are going to acknowledge that that is the legal description for the property. It's going to be based on either a title report or the last deed that's coming through. Now there is also a recommendation, because the other side of it is you want title confirming that, you want title to be okay with that. So I'm always okay with seeing the language that it's to be inserted by title once the title report is produced, or if it's not produced yet, having that put in. But the parties have to agree that that's essentially basically a instruction to escrow and title as a part of it. So I want to make sure that just you're not leaving that open and getting into it, because that will become a dispute when people say, if they're trying to go for a specific performance or anything of that nature, and saying, oh, well, you know, the legal description wasn't there. You know, the parcel number was there, the address was there. Everybody knows what property we're talking about. But when we're talking about the transfer of real property, the legal description is a critical part of it under the statute of frauds, and you have to have it there. And then real quick and briefly on the remedies election, that's another aspect of this that we'll talk about, because you see within these contracts, every single one, you're going to have an election provision, and we'll get to this in further slides, but you're usually talking about earnest money or specific performance plus damages. So we'll get into that. Mike, if you can go to the next slide. Okay, and this is what we're talking about here. Now, this is the Northwest MLS. This is Form 21. So this is your run-of-the-mill standard residential purchase and sales agreement. And on that first page, there's the default, which is the forfeiture of earnest money that's highlighted there, or seller's election of remedies. And so run-of-the-mill transaction, you're always almost going to see every time the forfeiture of earnest money. As a buyer, it's a great thing to have there. It's a known commodity. You realize that putting your earnest money up is part of this. If you end up breaching, there's the possibility of forfeiture of the earnest money. One, it helps you understand what the reality is, and it puts it down to some certain amount. And you do have to realize that also within Washington, we see some of these contracts getting a little more loose on the amount of earnest money, and you'll see substantial amounts of earnest money over 5%. Now, it's critical to keep in mind that Washington statute does allow for a presumption of 5% is liquidated damages. They're okay with that. That's in the statute. For forfeiture side of earnest money, anything over the 5% is not invalid by any sense, but that just has to be proved as a actual consequential or specific damages that's related to the breach. So if you want the presumption of everything is okay, it's up to 5% of the purchase price. Anything over that, it's a more of a burden and a requirement on the evidentiary side. And this is also in Form 21 there. You have the default provisions, and it just lays it out. So you just want to make sure, you know, going through these processes as a buyer or a seller, one, you want to make sure that box is checked. It's not funny, but I see it a lot that just a box is unchecked and nobody knows. No, it was just a missed process during that. So just make sure everything's getting through there. And Mike, if you can go to the next one. And we'll kind of touch on the commercial transactions as well here with EMONs.
Yeah, and they're very similar. Some of the big pieces here, and these are also just tips for things that we're seeing out there in the marketplace right now, where we're just, they seem to come up more often and more frequently, and this varies. Obviously, remedies election, which we'll cover in the same way on the CEBA form, as Rob just did, is very similar. Then in the assignment provisions are just much bigger in commercial transactions. The CEBA form is very well laid out for this, but in ones that are drafted by attorneys, we spend a lot of time talking about what an affiliate is, under what circumstances assignment can happen. And it really depends on the type and style of transaction, how vigorous those are negotiated. Survival period's another one. It's changed over the last few years. It used to be kind of something you'd haggle over a year to 1 year. Now it's like 6 months to a year. That's because these transactions, if you don't have any survival period, they merge all the reps and warranties in the deed, merge with the deed at closing. And so everyone's learned to be very specific and have them survive closing. But for how long? And if it just says they survive closing, that's a 6-year period for a statute of limitations. So another one that's very common right now is reimbursement of due diligence costs on development sites. So if you're buying a several $1 million piece of dirt that doesn't have anything on it, typically the expense is quite high to do due diligence on it. So it's not uncommon to see something that says, hey, if you're a buyer and you spend a bunch of money based on the doc set that's been prepared by seller, hey, here's everything we kind of know about the property, and then oops, 2 months go by, we omitted this environmental report we had, and buyers spent a few $100,000. Typically you're going to have a clause in the agreement that says if seller breaches this agreement before closing by breaching these reps or warranties or providing a document that's not complete, buyer will have the right to collect its out-of-pocket expenses up to some amount. 100,000 is usually typical. And finally, another thing, we're seeing a lot of damages caps, which we never used to see. But again, as transactions get larger and as these sort of turn into retirement assets, people think a lot about saying, look, we're going to limit our damages on this sort of 10% of the purchase price or something like that. So real quickly, we'll go through the CEBA forms on the elections remedies. Again, you've got to check the box situation. Absolutely similar to the MLS form. Again, similar to the MLS form, people sometimes just do not check these boxes. Critically, it directs you then to 41. And the key thing about section 41, which is way down, I think on like page 12, is that it covers both of the elections, even though you only get one of those two. So you just know that, if you check, you're not getting all these unless you check the appropriate box. And the keynote, if we go, keep going forward. Yeah, so you're really, the key one we're focusing is on the right to bring C, Roman numeral is A, Roman numeral A, Roman numeral 2, and then subparagraph C, bring suit to specifically enforce this agreement and recover incidental damages. And you, and then you've got a seller's default provision in Roman numeral 1 and 2 covering this as well. If you elect specific performance, we'll talk about this too, you're not getting your damages beyond your attorney's fees unless you've got a selected additional remedies here. And that's big to my point earlier about out-of-pocket expenses and costs that may have been accrued that are actual. That's all out the window. So moving to onto the next slide, this is going to get us into what exactly specific performance is, and we're going to try and take you through the legal side of this real quickly, and then sort of give you a play-by-play of how this actually goes down, because we get these calls all the time, and this, hey, we need a specific performance action. It's like, so it'll be great to kind of cover this quickly.
Yeah.
First piece of this, Rob.
Yeah, I was going to say, so specific performance, I mean, just the history of it is we're really talking about the court has a difficult time on monetizing very unique things, right? So where it comes in all the time, obviously in real estate, is no two pieces of property are exactly the same. So when you're talking about specific performance, you're really requesting the court to say, hey, whatever the contract was saying for this piece of property, I have the right to purchase that, and the court has to order the other property, the other, you know, in this instance for specific performance, it would be a buyer asking the seller to fulfill the obligations and sell the contract via the contractual terms. And now where that gets pretty drastic in the sense of if it comes to that level is these forms and the law is talking about specific performance plus incidental damages. So when you've got a market like you've got right now, the incidental damages will greatly increase the loss of profits, essentially, if you are a seller, right? Because if you're talking about, you know, interest rates right now, we all know those are moving up. They're going to be ticking up. So you can see that as a rational approach to damages. Somebody has to now pay more and incur more fees for a loan. You're talking about due diligence costs that are incidental, that if they don't go through with it, and you've spent all the development, maybe you've gone through phase 1, phase 2 on the commercial side, and you're spending all this money out of pocket, and the seller just at the time of close says, you know what, no, I'm not going to close. You've got to vet all that, add up the damages and see what it is and what it's going to take. And now the one thing to remember for specific performance is, one, it is through the court. Nothing moves fast through the court, right? So there's a lot of variables that come into it. And when you get to that point, you have to really acknowledge and understand that it may not be the quickest process, right? You're looking at everything. And that's why leading the charge with every box checked, everything done correctly on the purchase and sales side of things is the best approach in going into that, because it's a very drastic remedy, but it's also the most applicable for property. So if you see there, and the definition there, it's intended to put the contracting parties in the same position they would have been had the contract been performed. And that's why the court is okay with the incidental side of damages as well as the award. So the big kind of practice tip here for anybody in the world of real property is do not sign a contract to sell property unless you are intending to sell that property. I mean, getting into these, and in this market, we saw it a lot where another offer comes through the door right after and it's for hire. And then people are looking at, hey, what do we do here? Do we go into another contract? Trying to add up the damages of, oh, okay, well, if we just pay them this much, we can take this higher contract. If you are signed into a contract and a buyer's frustrated with it and the buyer's ready and willing and able to perform, they may choose that route, a specific performance. And then you're stuck with a much lower amount than you would have necessarily got, because you're paying their attorney fees, you're paying your attorney fees, you're paying incidental damages, and you're still being forced to sell the property. So it's just the most critical piece of advice there is, if you're selling, be aware that once you sign that contract, you're going to be held to the terms of the contract. All right, Mike, you can go ahead and go to the next slide. Yeah, so as we talked about, the validity of the contract, obviously, in any kind of specific performance case, when it gets to the litigation standpoint, people are overturning every rock. They're looking at everything going on, trying to see if there's some technical defense to the validity of the contract. Now, that's one aspect of it on the technical side. The contractual side is still, I mean, that's a hard thing to get out of. When a court is looking at this from the perspective of a clear seller breach, and then we're going through the realm of the technical defenses, those might pop up, but you got to understand that in my experience, when it gets to that point, the court's looking at it going, you sign this and now it just looks like you don't want to sell. So you've got that backdrop that you got to be ready to get over if you are a seller and you're trying to prevent specific performance. And as we were talking about before, the legal remedies, meaning the monetary damage for a specific piece of property, the court has basically said in specific performance that that's inadequate because of the uniqueness of real property. And so they do add on, and that's kind of a funny take here, is the monetary damages, i.e. general damages versus incidental, and what that adds up to. So it's good to see that the courts and legislation is recognizing that it's not just the property in and of itself that's a damage once it gets to this point. There's the incidental costs that go into it. And then as it says there at the bottom, you can't have both sides of the coin, right? And that's why within those contracts, and that's in the SEBA form, you'll see that it does say specifically, seek specific performance and incidental damages. So at that point, both parties are agreeing that the specific performance is a part of it, and the incidental damages that go with it will be a part of the lawsuit. And that's different than just a damages for the breach of contract.
Next slide here, Mike.
Go to that next slide.
So these are the
Yeah, go ahead.
particular elements, and we'll not spend a lot of time on all of these, because some of them, as I've noted here, are just obvious, right? In a real as to real property transactions. Okay, now don't take this and apply it to painting a house or something like that, because they're totally different, and they're different, again, to the point Rob made, because real property is unique. And when we say unique, we mean absolute in the most absolute sense, right? There can be no two parcels of real estate that are identical. There can't physically be. So courts have a real easy time saying, okay, yeah, you got to sell it. And they have a real easy time meeting this first one, which is a legal remedy wouldn't be adequate, right? You wouldn't, no amount of money would work. I want that piece of property. Obviously, personal services are out because that's pretty easy to accomplish elsewhere. And it may be the case that it just cannot physically possible. Which often is the time when you're saying, come paint my house, and they physically can't do it, which is another one that comes up. If it's just impossible, and we'll talk about it, you can't compel someone to do it. The biggest one on this, there's really two major ones that we'll talk today about, which is the terms of the agreement are sufficiently definite to make the act sought to be enforced unambiguous. It can't, and the main thing here is that the legal description is the property, and it's very clear, and there is a purchase price that is very clear, and there is a closing date that is very clear. Those things, if they're not, and the parties' names are all there. If it's not definite, they'll just back away. Pretty easy bar to meet, to be honest, but they do have to be, the ones that we see most often in this argument are the impartial legal description, which we'll cover in a little bit as well. The other big item here is that all conditions precedent have been met by the party seeking performance. And then that's, as Rob mentioned, what we're talking about when we say ready, willing, and able. That means that the buyer has done everything that they were supposed to do, and would be all that's left to do is sign is transfer funds, and all that's left to do on the seller side is sign the deed, and they could do that. And everything would go away. And if we're not there, then we're really not in a specific performance land. In other words, if you didn't waive your contingency and you let the contract die, or you missed a time period, that element of this isn't going to be met. So Mike, next slide. So real quickly on this one, couple legal points that we'll just kind of move through real quickly. You can't move someone to do something, i.e. sell you the property, that they cannot do. So this is why getting the right entity and the right name of the person or the estate or anything like that, or the power of attorney that's necessary in place, if it's not possible, the court's not going to let you do it. The next one has to be actual binding contract. Obviously fraud cannot work, and there cannot be some kind of meeting of the minds that's been missed. And then finally, all of the material terms necessary. And to convey real property in the state of Washington, you need a legal description that is accurate. And if you miss one of these basic items, then you're just not creating a binding contract. And the case on point actually speaks to this and just says, yeah, no, this isn't specific enough to be enforced. A parcel of this chunk of bigger land without any real actual legal description, not good enough. So next slide, Mike.
On that same point, just something that just gets to this slide as well. We're talking about the plaintiff must perform. Now, we see a lot of the times that there's something going on and the seller early on, and the seller does what's called they anticipatorily repudiate the contract. They take some action that makes it abundantly clear that they will not go through with the sale, and they've demonstrated that. They've said it over and over again, I'm just not selling, right? And a lot of the times, especially in the commercial setting, you're very early in the feasibility state, very early on things that could technically be a part of the condition precedent of the contract, right? So if you're still in that realm and it's early on and they're showing unequivocal acts of breach, that is still an opportunity, even though you as the buyer are not at that stage, as we're kind of talking about, like money's ready to exchange. You are asking for specific performance of the contract, meaning you're holding them to what they have to do under the contract and those terms of the contract. And so it's not necessarily that I don't want everyone to think that you've got to be ready at the signing table, ready to give up money to ever have a chance at specific performance. It's a little more different when you're talking about a seller that's saying unequivocally they're not going to sell the property, and that's made clear. You can still move for specific performance at that time of the terms of the contract.
And it happens often. A lot of these come up way prior to closing. We're told that a seller is just not going to sell and has decided not to sell. And the letter from us is, okay, we're performing, we have performed, and our buyer is still entitled to make this happen. And here's what's going to happen next. So with that, next slide. So I thought we'd walk you through sort of from a seller's perspective on these calls, our kind of what happens in the real world from both seller's perspective and obviously a buyer's perspective. Seller's perspective, pretty easy, right, Rob?
Yeah, exactly. From the seller's perspective, I mean, it's kind of funny to think about because obviously there's only two real options here. They either want that buyer to finish with the contract, right? And depending on the election of remedies there, they're either going after the forfeiture of earnest money if there is a breach, or if they did elect remedies, they could look at the monetary damages caused by it, meaning the breach of contract, everything that stemmed from that, which is a rarity, but you see it from time to time. But then from the seller's perspective on, I don't want to sell, right? That's just, yeah, most of the time you see the hunker down and just start looking through all the contracts for some technical argument.
Yeah. And you're looking through all the emails and all the notices and going, was there actual performance? And sometimes it does happen that the buyer hasn't actually performed everything that they're supposed to. And we'll talk about a few things that seem to come up often. But for the most part, it's a tough sell on the seller side. You don't want to be in that world.
Yeah, and that's
which brings up a great point, which unfortunately I see once maybe every couple of years in my 15 years of doing this, is the inadvertent broker sale of the property to two different parties. You don't ever want to be in that world because what ends up happening is you pay to make it go away. You typically the broker, to be honest.
And that's a good actually tangent to something that I think is a good practice point for brokers, is a good item for owners, sellers out there, buyers, everybody. One is know the contract before you sign it. There is a lot of automatic termination language within these contracts that, you miss it by a day. The term of the contract says, let's take, for example, the feasibility terms within the SEBA form. That's an automatic termination if they don't provide the notice of satisfaction. And then, so if that time frame passes and there's always an argument that a party has waived that, they didn't send it, but they continue going down the street as if they were going to confirm the sale, there's waiver arguments, that becomes a factual issue, but you still are dealing with the backdrop of a contractual provision that you guys both agreed to that said this is automatically terminated at this point. So it's just something that's critical on the time frame side, and just something to look at from everybody. Just know your contract, know the language. I've seen it a number of times where in this new day and age where we're sending out documents for e-signature, doing things very quickly. I mean, it's great. It's an awesome tool and to be able to utilize and get stuff done quickly. But it's also, I see it popping up more and more where people are claiming, well, my attorney just sent me this, or my broker sent me this. I didn't read any of the terms. And you're going,
yeah. Well, also to be clear, most of the time that we see this is caused by a failure to rescind an offer and counter offer in that exchange. It's really hot and heavy. We've got all these bidders and they're all bidding. And like most of the time that this comes up, it's a counter offer went out signed with an expiration period and another counter offer went out and now both come back. Well, I thought it was going to happen in a different period or whatever. And it's just, you got to stay focused if you're in that mode. You have to know exactly where you can, if you've got a rescission that you've got to send out or whatever, do that. Do not have multiple counter offers out when you're in that mode. It seems very obvious, but it happens. So then from the buyer's perspective, and this is real tough because you get the call, and in this current market, we all know what buyers are going through on the residential side. It's just sort of not a fun experience, and you've already missed out on 8 homes, and now here we are, and for some reason the seller doesn't want to sell, and now we've got to move out of our house. We've already scheduled to move. This is our dream home, and then now we're dealing with this. And the reality is, if you have to file a specific, if a letter gets sent saying, okay, specific performance, we go through all of the stuff and it looks like buyer has complied, you are still in a sort of litigation world where the other side, now it's past closing. And how much time does this take? Yeah, the forms typically in the CBA and MLS forms, you have to file within a certain period of days. But the litigation system right now, as Rob can tell you, not super quick. You're not getting, so it's not like a closing, and that whole delay and everything that's happening. The reality is, if you go this route, you're still filing a lawsuit, a complaint for specific, serving that, and then some number of days before you get a hearing on a motion for summary judgment, Rob, if I'm not mistaken.
Yeah, I mean, there's different factors that go into it. There's the injunctive side. There's a lot of things going there. But yeah, litigation is a long process. It's a long and expensive process. And unfortunately, we're not the attorneys are not the ones that actually decide it. It's a third party that has no emotional attachment to it. It's just looking at it from an outsider's perspective. And, it's kind of a common theme, like maybe they had a bad lunch today, didn't like the way your client smiled.
Yeah. And what is it like? I think it's like 99% of clients calling up with a specific performance action say they've got a slam dunk. This is a slam dunk. You're just like, okay, well, 80%, even on your best day on the slam dunk cases, you have a 20% chance of losing for everything Rob's saying. Like, you just don't know. As much as we're saying like, okay, this is sealed, you got your deal done and it's binding. Yeah, you're probably in a good shape, but you're never going to hear any attorney worth their salt say, all right, we're going to win.
Yeah. And I do actually want to touch, because I apologize for the people out there that did have some questions and answers. And there's one that just popped up earlier that I didn't get to. But there's kind of the question of, hey, the Form 17 one, one of the attendees was pointing out that there is some legislation to amend that to remove the don't know option. So that's, and then there's also the questions of, as a seller, why wouldn't I just say don't know to everything? Just go down the list. Don't know, don't know, don't know. Right? It seems like a perfectly fine and acceptable way to do that and limit liability. Now, the issue with that is, if there's something you have actual knowledge of and you're saying don't know, that's actually a misstatement, right? There's a time and place for the don't know, but it's not you can't just go down the line and say don't know for everything. And again, I know it's odd to say, because sellers don't like filling this stuff out. They think, hey, why am I giving up information that could possibly detract from the sales price or do something that could hurt the sale on this form? The reality is that form is there to protect the seller, to give as much information to the buyer, because it's a buyer beware state. And if they're going through with the transaction and they haven't objected to what's being stated in the Form 17 or anything of that nature, they are going to have a very, very difficult time on the back end of ever claiming any misrepresentation or concealment if you have appropriately and correctly filled out the Form 17. So yeah, it's an added protection that's an oddity to think about, because no one wants to fill that out because it's talking about possible issues with the property. I always recommend full disclosure. No one wants to deal with the lawsuit on the back end. So that's my.
And this is a marketability piece too. If you're out, especially in a hot market like this, if I'm involved in something, you know, and we look at a Form 17 and it's got all the asterisk boxes, and then there's an exhibit and it's nicely typed out, and the invoices for the repair job that happened are attached, I can tell a client like, look, does this mean they're the most honest people in the world? I don't know, but are they filling this out properly and giving you like full disclosure on stuff? Man, yeah, they are. That's a great sign. Well, go bid your heart out, you know? And if on the flip side of it, if they check an asterisk box, yes, and they say, you know, roof leaked in 95 and there's like nothing supportive or anything with it. Again, there's a fine line here, and I'd talk to your attorney before you go filling that out for the most part. But like, if you've got a group of buyers looking at it, they're kind of like, okay, well, this doesn't feel shady to me. So there is a marketability component there. And on the House Bill 1951, and I think there's a couple other ones out there. What I would just say generally is this Form 17, as we call it, Form 17, it changes every couple of years. There's a change to it. So don't get caught using an old form. And it happens. You'll see it and you'll be like, oh, that's the form from 2007. And so they do add some language. They do the one other thing that's on the table, not just removing the don't know, but they're talking about adding a disclosure for whether the rodents or infestations have chewed any wires on the property or chewed into exterior surfaces. You know, that could come down, that could get approved or not. But you want to check sort of annually at a minimum. And I know if you're using MLS forms, they're gonna print only the most recent stuff, but you need to be up to date on that form. Okay, next slide. And I think we'll kind of skip through this one as we've kind of covered all of this. Obviously, we're going to come in as the seller and try and pick apart your deal and find anything that we can to make it so that you don't have a cause of action. But I don't think we need to spend time going through each of these individually. Next slide, Mike. Okay, so this one, I do want to just touch on the key points here to take home with you. Obviously, make sure the purchase and sale agreement is specific in its legal description. If you don't have a legal description, we've got some links that we're going to send out that are a good place to go, or if you can get a preliminary title commitment, that's always the best bet. But do not use the abbreviated legal description that's on the parcel viewer. We see that all the time. It's kind of laughable. It's like, oh, somebody who hasn't done a lot of deals. Okay. And then Rob will talk to us about some of these strict compliance with critical dates.
Yeah, and this is the one I see the most when it comes to it. I touched on it earlier with, you know, inspection, due diligence, feasibility, but it's great to see it from a lot of the brokers that I work with. I love seeing right when that is mutually executed, they've got the timeline that's all spit out. It says exactly what date, what's coming up. I mean, that's just such a great asset, one, for your clients in general as a broker for any buyer or seller, but two, just setting the standard so everybody knows what's going on. It's not a good feeling to go to bed every night and say, oh, was there a deadline coming up? I don't, you know, the sale is going through, but I think there's something on the table, and then you wake up and you've missed a deadline, or there's a period that is run that you wanted to put in, like as Imams was talking about, the title objections. Sometimes you just won't see any response to it. And then, you know, what happens there is sometimes there are title objections that are required to be removed by the seller at the time of closing, that had you just said, no, I object to it, the seller or the buyer would have been perfectly okay to that and would have remained. But now you're stuck in a place where you're possibly telling them you're going to remove, you know, an easement, or you're going to remove something that you have no ability to remove. So it's, you know, keep up on that, keep up on the title and the objections, inspection, diligence periods. There's one that comes up actually quite a bit, especially in a very hot market, is earnest money and actually getting that deposited. We could have a whole nother seminar on this, because it's just one of these things. Is you're kind of in this gray area of, you sign the mutually accepted contract. Normally you have, you know, 2 days to deposit the earnest money. Earnest money doesn't get deposited. Where do the parties stand at that point, right?
Or it gets deposited on the 5th day in a document that says everything's going to be strictly complied with. Well,
Yep.
that's 2 days late. Where are we at that point?
Yeah. And so yeah, it raises a whole cast of issues. It can come with that. But one of the big ones that we see on the specific performance side is at times you won't see a rescission or a termination of the prior contract that didn't get the earnest money provided. And then the market, property goes back out on the market. Another contract gets signed, and then you have a buyer out there that's either understanding that now there's actually 2 contracts because the other one was actually officially rescinded. Because if they did attempt to provide the earnest money and you hadn't terminated or rejected, there's an opportunity for them to declare that, hey, I'm still under contract on this. So there's tricky situations. Like I said, I mean, I could go for days. We could have another seminar just on that alone, but I'm looking at the time and we've already blasted through.
Yeah. And I think this last one is just be ready, willing, and able. And quickly, what does that mean? It means that you were all the way through. You got your financing lined up. Do you have to be standing there with your pen in hand? Probably not. Would it be good if you didn't know any better and they hadn't breached yet? You should be there ready to sign whatever loan documents. Yeah, all your loan documents should be signed and in, and you should be moving it forward as best as you possibly can, as if you're going to close, because every step to the contrary is going to kind of get argued in your face. So the next slide here, just parting on this, unless anyone has questions as we're doing this. These are kind of the big websites that we use all the time. King County Parcel Viewer, Pierce County Parcel Viewer. Obviously, a lot of other counties have parcel viewers. These are the big counties we operate in. The recorder's offices, Pierce and King, are where these typically you can get a deed that has a full legal description on it. That legal description can change. So that may not be your best bet. Your best bet is a preliminary title commitment from a title company that is about to issue a title policy. Sometimes that's tough. So, and then finally, we get asked all the time about some of these forms. They're available on WSBA.org. These are LPO, limited practice officer forms that the escrow companies use. Again, don't use them if you're not an attorney or limited practice person, but they are there, and it's good to know they're there, and it's a resource to look at. What does a promissory note look like, or a deed of trust? And those are available PDF and Word, and you can work with your attorney if you want to use those forms, and they can help you edit those. And we frequently use those to try and keep costs down for our clients. With that, I think we've answered the questions we had. If you want clarification on anything, as always, you can reach out to an attorney or Rob or I at the firm. Happy to get you signed up and help you out. Today was for informational purposes again only. Shouldn't rely on anything we say as legal advice. Tell we're your official counsel. That said, we're available here. Our contact information is here, and this is a recorded webinar. It goes up on the YouTube channel. An email will go out with a link to this, and we will be back online, and we will likely have another major webinar on just the changes to the SEBA forms that just came out. There's been a lot of easily readable sort of materials that are good, but we'd like to cover some of the things we're seeing and get out ahead of some of the trends that we're seeing as that new language kind of unfolds. So we'll see that in the future. Thank you for joining us. Rob, awesome as always.
Thanks, guys.
We'll see you all next time. Thank you. Bye.